Conditional acceptance success example video numero 1 of many. This is from a client who was receiving food stamps and then received this letter from the Vermont Agency of Human Services letting them know that we have found your household received $2,000 more food stamp benefits than you should have for the period of September 1st, 2010 to June 30th, 2011 because we made an error. Because your household no longer gets food stamps, you must repay the whole amount now. Or contact me by August 27, 2011 to make a repayment agreement. Make your check or money order too. If this claim is not paid, it may be sent to other agencies or to the federal government for collection. They will use various methods to collect the money. You may make a written payment agreement to stop this from happening. If this claim becomes delinquent, your household may have to pay processing charges. You may inspect and copy records related to this claim. We may reduce any part of your claim we determine your household is unable to pay. If you have any questions, please call me at the number shown above. Remaining balance, $2,000. Remember, folks, ladies and gems, this is just a contract offer. Do you get it? More on that in other videos. It's just a contract offer. That's why they say we may so many times. Isn't this cool though? When I saw this, this was crazy. We made an error. So let me show you our response. This is a private communication between the parties. Notice to agent is notice to principal. Notice to principal is notice to agent. Notice of conditional acceptance. This is our client's address, care of the notary's name and the notary's address. Sorry, this is our client's name, care of the notary's name and the notary's address. Registered or certified mail. Nunc pro tunc because they didn't respond within 10 days. So you want to, nunc pro tunc is Latin for now for then. Now for then. Okay? So you can simply, if you don't, a contract takes 72 hours. 3 days extra for the mail to arrive, 3 days extra for the mail to come back, 1 day for a Sunday where there's no mail. So a contract takes 10 days. If you don't respond within 10 days, you accept the previous letter. Now, this client hadn't responded because they hadn't gotten to me in time, and so what we do is we just write nunc pro tunc to month, number, year. And therefore, the letter has the legal force and effect of being responded to within that 3-day time frame, or within that, you want to make sure that this date is within 10 days from when you receive the previous letter. Okay? And we're sending it to the head honcho, the chief executive officer, so that nobody can say, this didn't get to the right person. We're just sending it to the head honcho. Or this person doesn't work here anymore, or you sent it to someone in a different agency. We just send it to the head guy most of the time. That's what we do. And you can CC the person, if there's a name that was sent, it's good to send to multiple people. So our response that helped our client succeed. I am in receipt of your letter dated August 15, 2011, a copy of which is attached herewith. In response to your letter, I'm conditionally accepting your offer to be liable for your department's error for the amount of $2,000 or of any amount upon proof of claim that, number 1, you show me where we have a contract to which I become retroactively liable for a mistake or an error, like they said, we made an error, made by your department. Yeah, I'll pay this. Just show me where I have a contract saying that I would pay any mistake that you made. That's your fault. And number 2, I conditionally accept your offer upon proof of your claim that I receive your department's documentation of accounting showing evidence of your loss. You just show me evidence of your loss, and that's so we need both of these things, and then we'll agree to pay it. So we're not arguing, we're not disagreeing, we're not opening up a dispute. We're conditionally accepting, which is way more powerful and keeps us in control and will ultimately lead to a success in this example and lots of other examples. You have 10 days from receipt of this conditional acceptance to respond on a point-by-point basis via sworn affidavit under your full commercial liability, signing under penalty of perjury that the facts contained therein are true, complete, correct, and not misleading. Mere declarations are an insufficient response. And that's what they do, is they respond. They did not respond under penalty of perjury. We'll go to the letter in a second. So therefore, they sent us an insufficient response. If an extension of time is needed to properly answer, please request it in writing. Failure to respond will be deemed agreement with the facts stated in the attached affidavit and an inability to prove your claim, thereby indicating your agreement to the facts stipulated herein enclosed commercial affidavit. This letter constitutes constructive notice to the recipient. Name the actual date. You don't backdate this part that you write. And then you write, any and all responses shall be directed to me via USPS certified or registered mail at the following address. Whatever your name is, John Smith, C/O, the notary's name, comma, notary public, the notary's address. Service in any other matter will be deemed defective on its face, meaning it's an insufficient or frivolous response if they send it to anyone other than the notary. The notary is witnessing the whole communication between them and us, and if needed, they can send evidence to a judge under notary seal, in camera, marked private, and the judge will rule in our favor every time without us ever having to go to court. Okay? Jurat. Or without us ever having to go into a public courthouse. Because we're in court. Writing this letter back and forth to this agency is technically court. Look up the definition of court in Black's Law Dictionary. They give you a little homework assignment. Jurat. Subscribed and sworn or affirmed to me before on this first date of June 2012, whatever it is, by John Smith, proved to me on the basis of satisfactory evidence to be the person who appeared before me, signature. And then the notary's going to put their stamp here. Alrighty, and then, actually, you do not need this in a conditional acceptance necessarily. You need this at the end of the affidavit, but it doesn't hurt to keep that in there. Affidavit of specific negative averment. The undersigned affiant, John Smith, refers hereinafter affiant, does solemnly affirm, declare, and state as follows. Affiant is competent to state the matters set forth herein. Affiant has knowledge of the facts stated herein. All facts herein are true, complete, and correct, admissible as evidence, and if called upon as a witness, affiant will testify to their veracity. These 3 points are always going to be the same for any affidavit or negative averment affidavit. Now, a negative averment affidavit is very special because we're putting the proof on the other party, and it just works out in our favor a lot easier. There's no way of us, this is misnumbered, there's no way of us ever putting ourselves at risk for being in perjury. If you sign an affidavit, you're putting your commercial liability on the line. But look how we word this. This is the whole point. Affiant has no knowledge of any existing contracts between the client and Vermont Agency of Human Services Department for Children and Families Economic Services Division, which holds the client retroactively liable for mistakes or errors made by Vermont Agency blah 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 or their agents. And affiant believes that no such evidence exists. That's the format. Okay? If this was an IRS issue and you haven't paid taxes for 5 years, let's say, you might word it like this. Affiant has no knowledge of any tax liability for John Smith, the name in capital letters, social security number, or whatever company, an EIN number or whatever, in the years 2006, 7, 8, 9, and 10, and affiant believes that no such tax liability exists. And then it would be the IRS and their responsibility to write an affidavit back, swearing under, someone would have to swear under penalty of perjury, saying that you do have tax liability. And if they don't, hey, an unrebutted affidavit is truth in commerce. So the bottom line is you can't prove anything, and you put the burden of proof on the other party, and if they don't respond, then your affidavit stands as truth. That's how it works. That's how commerce works. Affiant has no knowledge of whatever, and affiant believes that no such evidence exists. If they don't respond, you have 10 days from the receipt of this letter in which you can respond to or rebut this affidavit of specific negative averment, unless you request in writing an extension of time. Failure to respond or rebut shall convey your assent to and agreement with all the facts stated herein and witness thereof. Your name, upper lowercase, secured party creditor, authorized rep for the name in all capital letters, the corporation, jurat. This is where it's really important. You always got to have a jurat for the affidavit. And then the notary witnesses your signature. You pull out your identification, and the notary witnesses that you did sign this affidavit, that is you, and they put their stamp or seal on there. And then you got your notary certificate of service. It is hereby certified that on the date below, the undersigned notary public mailed to. And then you just list. This is going to be the same format. You're just going to, whoever you mailed it to, and you're going to put the whole record, every letter, or every correspondence, the date issued by what person issued it, you or the other person, the date, how many pages, or we use the word leaf. Reference copy, okay. Total of 5 leaves by registered mail, placing same in a postpaid envelope properly addressed to recipient at the said address, and depositing same at an official depository under the exclusive face of custody of the United States Postal Service in the state of New York. Notary. So basically, this is evidence that we served the other party our notice of conditional acceptance, our affidavit of specific negative averment on a specific date, and if they don't respond to it, the notary is going to sign a certificate of non-response and put that in his or her files for the record. It's very important to have good record keeping of what responses are sent, which is why we use a notary. More on that in other videos. So let's show you how effective this letter was. The department has received your request for a reduction of your food stamp claim in the amount of $2,000 for the period of 9/10 to 9/16. The rules, and they cite our rules, state that we must use the calculations set forth in those rules. We have completed the calculation, and based on the formula, we are able to reduce the claim by $1,280, leaving a balance owed of $720. So instead of them wanting $2,000, now they only want $720. I think that they know that they didn't respond in an affidavit. They didn't open up their books to us like they offered to. We wanted to see evidence of their loss. This is a frivolous or insufficient response, and we do another conditional acceptance to this, and it'll probably go away. So they're saying, please pay an amount, otherwise we will send to collections, including withholding tax refunds, Social Security payments, and other federal funds. Please contact Hillary at 802 blah 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 to set this up. They're still just trying to get the money from us, and this is just, again, another contract offer. No legal force and effect, no commercial liability, no affidavit, no response to our affidavit. But you see how effective the conditional acceptance sent through a notary with a negative averment affidavit was, where we immediately got a response back where they lowered how much money they were willing to accept. Now, we're not going to accept anything because we're not liable. We never, the contract equals the law, and there's no contract that we agreed to be liable, and they agree with us as well. They give us an insufficient response. I hope you like this video.